Good morning. Thank you very much for joining us today. So today's quarterly legal and compliance updates is in partnership with JMW. Our usual disclaimer is that nothing today should be taken as or construed as official legal guidance or advice, and is for general information purposes only. But if you would like specific legal advice on any of the issues covered, or in fact on anything else, I am sure that our esteemed panelists would be delighted to hear from you, and you'll receive his contact details at the end of today's webinar. And with that, I'd like to hand over to David. David, could you please introduce yourself to the audience?
Oh, it's this bit again. Good morning, everybody. Nice to see you. Thank you for giving me the benefit of your time. And yes, my name's David Smith. I'm a partner in JMW Solicitors. Apparently, I know a few things about residential landlord and tenant law, but I always introduce myself that way, don't I? I need a less diffident introduction. I'm an expert in residential landlord and tenant law. There you go. There's a more robust introduction.
We go, and you are absolutely an expert, and we're going to hear about some of the things you've been doing as well. So without further ado, we'd like to cover off four key topics and a subtopic today. The first is something that we've been asked about a lot, and it's been a constantly changing feast. So what are the current rules for evictions? What is changing, and when is it going to change, assuming no further variation of the rules?
Yeah, and I think one of the things that's interesting, actually, as I was sitting thinking, oh, it'll all be fine now. But of course, Boris gave a press conference yesterday when he's quietly rowing back on the whole Freedom Day thing, and it might all change. So there are kind of two things to bear in mind. We've got a set of restrictions about notice service and assured short hold tenancies, and then we've got some court processes that are being used to sort of slow things up. The stay on actual evictions, so bailiffs turning up, banging on people's door and sending them on their way, has been removed. But I have heard stories, of course, of people claiming to have COVID at the point of a bailiff or high court enforcement officer turning up. Now, obviously, when I say claiming, I'm not suggesting for a minute they're lying. I'm sure there's a mixture. I'm sure some are telling the complete truth. Some are perhaps not. And there being a number of problems around that. There is no formal guidance on this from the government, and there seems to be a difference of views. Some bailiffs and high court officers are walking away. Some are literally pulling out tests on the spot and insisting that tenants actually stick tubes up their noses and take a test and prove they have COVID, which is a little bit illegal. So it's not quite clear what the plan is there, and realistically, it needs to be sorted out so that there is a process by which someone who has COVID can not be evicted, because it's not terribly practical to start throwing people with COVID out in the streets to spread their COVID around. And the current situation is a bit unclear for everybody. So bailiff evictions, in theory, are going ahead, although subject to that problem. We also have court working procedures. They are in place until the end of this month, and a little birdie tells me they will actually be in place till pretty much the end of the year, but with adjustments. So at the moment, we have two types of hearing. We have a review hearing and then a full substantive hearing. And this is all designed to slow the process down and delay it. However, what's really noticeable recently is that there hasn't actually been that many possession cases since we opened up the courts. And of course, there was a lot of shouting about the idea of a cliff edge of evictions and a vast swathe of eviction. And I and other people said that the evidence wasn't really there to support that. And if you looked at other countries where they'd had moratoria, there hadn't been some massive uptick. And in fact, there hasn't been. So in the last 3 months that we've been collecting stats for, there have been 3,000 possession cases started each month, against a pre-COVID number of 11,000 a month. So there simply hasn't been this huge surge of eviction. It may be that one will start to happen as we move through, and more Section 21 notices, for example, start to expire. But so far, there's been no evidence of a massive surge of eviction. And so the court rules are likely to be altered at the end of this month to try and to get rid of review hearings and to slightly speed up the process and to start to sweep away some of the sort of extra stuff. However, it will still almost certainly be a requirement for people, for example, to set out in documents for the court what they know about the effects of COVID on the defendant, on the tenant and the occupiers and the property. So it will continue to be important for agents to be liaising and engaging with tenants and just trying to find out whether they're not paying the rent because they don't want to, or because they have elected not to, or because they can't. And if the reason is that they can't, if that's something relating to coronavirus or just some other life event that is outside their control. Because that information will continue useful. Turning back to the more obvious bit, which is notice periods, they have started to reduce. The expectation is that will now all be gone by the end of September. But the key ones are that Section 21 notices are down now from 6 months to 4 months, and the expectation is will drop to 2 months later in the year. Section 8 notices for rent arrears are much reduced. It's now 4 months arrears rather than 6 months arrears to get the shorter notice period, and that will be dropping again at the end of this month. And the notice period is still 4 weeks. So it's sort of slowly edging back. And again, all of that will probably drop back to completely normal in the late autumn. So we're heading back towards a sort of return to normality in notice periods. If you don't have an AST, so you're outside the assured short-hold tenancy regime, so it's a license or a non-housing act tenancy, then all of the protections are effectively gone now, and those people can be evicted relatively freely.
Brilliant. Thanks, David. I think it's quite interesting that in the residential property sector, we're sort of returning to normal, or returning to a pre-pandemic set of rules and timeframes. But in the commercial property sector, everything's been kicked down the road significantly. I believe it's till the end of March. And the justification for that was the delay to the so-called Freedom Day by a few weeks, pushing out the ability of commercial property landlords to recover possession or to issue claims. Obviously speculative, but do you have any sense as to why there was a divergence of view or approach taken between resi and commercial?
I can speculate. I mean, I think you've got to bear in mind that they are very different things. There is ultimately more support available for residential people through either various government schemes that have been placed to replace salary, and through the normal benefit system, albeit that it's not all embracing. Whereas ultimately, there is no scheme specifically in place, apart from the much derided loan regimes, to underpin business. But and also, of course, it takes much longer and it's more complex to evict a tenant for rent arrears. A business, ultimately, if it doesn't pay its rent, you can go in at night and change all the locks, and it's a done deal. It's self-help forfeiture. So I think I'm not quite convinced the government's got the position right. I think getting rid of self-help temporarily was probably the right thing to do. I'm not sure that the government shouldn't, in fact, be allowing forfeiture through the courts in a more reasoned fashion. But we'll have to see how things play out. I mean, the difficulty there is that the government's desperate to keep businesses in place, but the reality is, I suspect that some of those businesses are dead ducks, and probably were anyway, actually, but COVID just pushed them over the edge, and they're probably unsalvageable.
Thanks, David. And just as a general flag to the audience, keep watching this space. So again, my speculation or hypothesis is that the rules around residential tenancy possession and timeframes are in fact predicated on an expected economic bounce, and the taper off of furlough having minimal impact because the economy will get humming again. If that is not in fact the case, I think these rules may be revisited. Moving on to our next topic, sorry, just before we do, as a reminder, and thank you very much to people submitting questions, please do submit your questions. We will come to them at the end of the webinar. So if you have comments, insights, questions, anything that you would like to share, please do so via the Q&A panel. On to right to rent check. So the rules have changed and will change again. What should agents be doing? That feels like the theme. Things have changed and will change again. David, can you explain, please?
Things have changed and will change. We could just say about everything, couldn't we? Things just keep changing. Well, I mean, obviously, the main reason that things have changed is Brexit. The government had indicated they were going to leave this for a bit longer, but obviously changed their minds. They're now really trying to push on with the whole Brexit thing, in part, I suspect, of course, to make ourselves look tough to our European neighbours when we're busy arguing about sausages and other such things of great national import. So the rules are getting more complex, and they're going to get a lot more complex now. And that's going to continue, I think. And this is always going to be the problem with right to rent. As soon as you come out of a relatively fixed regime where there's the EU and there's everyone else into our now much more fluid regime, I think we're going to end up with different deals for different people. So the starting point now is that European nationals no longer get special dibs in the UK. I mean, that's your essential point here. Just because previously, if you were from France or Germany or an EU country, you could come to the UK in general terms and live here freely, and therefore by default you've got a right to rent. That is no longer the case. So to reside long term in the UK, you must now have settled status, and the new right to rent checks are basically keyed to the idea of settled status. So we have two things ongoing now. The first thing I should point out, and people keep asking me about this, is that this doesn't change anything for someone who's already got a permanent right to rent. So if you're renting a property to a French national who has previously established permanent right to rent with you, you do not go back and say, "Ooh, you're French. We no longer like you guys. Can we check you again?" It doesn't work that way. So those people retain their permanent right to rent. Now, they may or may not have settled status. So the Home Office might well have an issue with them, but that's not your problem. That's a matter between them and the Home Office. You only need to concern yourself with new tenancies. Obviously, those same tenants, if they move into a different property for a different landlord, you will then need to check them under the new regime, but we don't need to go back and start poking through the past and checking people who previously established a permanent right to rent. Obviously, people who previously established a time-limited right to rent, we will have to recheck, as we always did, and they will need to be checked under the new rules. But for most of those people, things won't have changed that much. Now, just to make things interesting, there's multiple regimes now in place and different ways for people to come into the country and establish different types of right to rent. So we still have what used to be called the permanent and time-limited right to rent, although the government's changed the name to unlimited and limited right to rent, just to make it more fun. People with unlimited rights to rent are British nationals, Irish nationals, and people who have some kind of status in the UK that says that they can stay here on a permanent basis. Okay, now that might be a card or a visa or a document. It might be digital. So we're now also make it a little bit more complex for you. Some people will be able to prove their status by showing you a bit of paper. Some people will have to do it online. Some people might be able to do both. But it's not really up to you to choose. It's up to them to choose. You're not supposed to discriminate. EU nationals who have got settled status have a permanent right to rent, provided their settled status is permanent. EU nationals who've applied for settled status have a time-limited right to rent, and you will have to check that. People who have, and then the other big group of people that's really important are people who have come into the UK inside the last 6 months from what's called the B5J SSK countries, and now also the EU. So anyone who's come here from B5J SSK, which is the big five, which includes the UK, but we'll ignore them for a minute. So the big five is Canada, Australia, New Zealand, and America, plus us. And then J, Japan, S, Singapore, SK, South Korea. So anyone from those countries or any EEA country who has entered the UK through an e-passport gate, that's with a biometric passport that you can scan through a gate at the airport, has an automatic 6-month right to rent, a 6-month right to be here, and a right to rent to go with it, and they won't have a visa. So any of those people who can show you that they entered the country by showing you, for example, an airline boarding pass, either on their phone or a physical one, and showing you their biometric passport, is entitled to be here for 6 months and establishes a right to rent for the normal minimum eligibility period of 12 months. Okay. Anyone else needs either a visa, so some kind of proper stamp in their passport, or they will need to have digital status because they're EU nationals using the settled status scheme. Raj, you're just frowning, which just makes me think that it's too complicated.
You're explaining it incredibly clearly, but it feels like, and I don't want to put you on the spot, that some kind of flowchart at the end of this might be something that we could perhaps put together, because I can see the questions mounting up already. But please continue. So I'm frowning because it feels like there are multiple permutations, and trying to get the people in the right box may practically be difficult, unless, of course, you have a suggestion on how practically agents on today's webinar might be able to handle this to make sure that they're following the right rules, the right times?
I think the thing to do is the first things first is things haven't changed. Anyone who had a permanent right to rent still has that. So let's just park them for a minute. People who are on time-limited rights to rent will be much the same, because most of those people will have entered the country on a visa to get their time-limited right to rent. Nothing changes for those people. It's visa checking, and it continues to be that. We then need to talk about new people. People on time-limited rights to rent are people who have got visas or have applied for settled status. So anybody who's coming from outside the EU with a time-limited visa of from outside the UK or Ireland with some form of time-limited visa. Now, they might be coming from the EU, they might be coming from somewhere abroad, but anyone who wants to come into this country for more than 6 months now must have a visa, regardless of where they've come from. Okay, now some of those visas will be easier to get than others, but that's not your issue. You just need to establish whether or not they need it. People who have come into this country from B5JSSK or the EU inside the last 6 months have a 6-month right to be here, and that means they can have a 12-month tenancy because the right to rent proceeds in 12-month chunks. The fact that they might overstay their 6 months is not your problem. You just need to worry about whether they've got a time-limited 12-month right to rent now, so you can look at their passport and their boarding pass, and that will cover a lot of people. And then you need to deal with people who have been here for a while and have got settled status. So EU nationals who were already in the UK and are remaining here will have settled status. That is now done entirely digitally through the Home Office settled status website. And there is a digital mechanism. And over time, more people will shift into the digital system. At the moment, it mostly covers people with settled status. The great ambition for all of this is that everyone will be through the digital system. And it won't just cover, in fact, their right to rent, it will also cover their right to work. Because what, of course, the government's really about here is getting rid of so-called benefit tourism. And the principle being that anyone who's in the UK from abroad is here to work, or they're an asylum seeker. Those are the two sort of mechanisms that will be here. There'll be no other way to be here. Obviously, a spouse of somebody, but primarily you're here to work, study, or for asylum purposes, and that's it.
Perfect. Thank you, David. And you just touched very briefly there on right to work coming under the same regime. It's definitely, so this is just to clarify, right to work, not right to rent, but there's been an adjusted right to work process in place during the pandemic, and for some people on the call this may be relevant. The adjusted period, so the period where you can do the adjusted checks, comes to an end as currently planned at the end of August, after which things revert to the usual right to work check. So for any people on the call who employ, this will be relevant, and it's worth checking out the government website just for some clarity around that. We can see the questions piling up, and we're going to make sure that we have sufficient time in the end to deal with as many of those as we can. Just moving on now, Northwood Solihull. So this is a case that you're involved with, David. Are there any updates that you can share on that? Because I know we talked about it in the last quarterly update, and there were loads of questions and quite a lot of commentary in the media around it. What updates can you bring to the audience?
Well, I mean, the instant update is we have permission to appeal, although I should point out, so does the tenant. And broadly, we are looking at a hearing date in November time, probably. That's still to be bottomed out, and we need to get dates together, but we're looking probably at a hearing towards the end of the year. And that will probably mean a decision before Christmas, which will resolve this problem one way or another, once and for all. Obviously, I point out the tenant has also got an appeal in, and their permission to appeal has been given as well, which was kind of inevitable, but that would also mean that Section 8 notices, and by inference, Section 21 notices, will end up having the same position. So if I was to lose everything, that will mean that tenancy deposit protection certificates and Section 8s and Section 21s will all have to be signed by two directors or a director before a witness for any corporate entity, potentially. No pressure.
Thank you. And just for those people who weren't on the previous webinar or haven't seen the commentary, it's about where an agency signs those documents on behalf of their client. So do you want to just give a 30-second overview, or is that sufficient, do you think?
Yeah. So, I mean, the summary position is how do you deal with the tenancy deposit protection and prescribed information documents, which have a certification that everything the landlord or the agent has said is true, to the best of your knowledge and belief. They have to be signed. So hopefully, although I do still see cases where they're not being signed, they all have to be signed by the landlord. They can also be signed by the landlord's agent on the landlord's behalf. The problem there is what happens if the landlord is a corporate or the agent is a corporate or an LLP, which most are. And the reality is at the moment, most agents just get somebody to sign, who could be anyone from a staff member through to a director, but just with a single signature. And in some cases, people use some kind of faux electronic signature with just the name of the company, as opposed to any individual. The position at the moment from the High Court is that those documents have to be signed in the same way that any corporate entity must sign a formal document, which means that it needs to be two directors, or a director and a company secretary, or a director before a witness, or for an LLP, a member of the LLP before a witness. So signed in accordance with the Companies Act, which for obvious reasons is deeply impractical. And of course, potentially a huge issue for the past, because of course this doesn't just apply to today. This is all deposit certificates for years and years and years back.
And how does that then play with the potential for penalties for incorrect provision or non-provision of a valid deposit certificate? Does this all interrelate as part of the case?
Yeah, I mean, it's frightening. I mean, the potential here is that people are liable for 1 to 3 times the penalty for not just the current tenancy, but for all renewals back through time. And you may have got situations where you've got multiple renewals and people have multiple sort of obligations.
Thank you. Well, look forward to hearing an update on that in the next quarterly update, to the extent you're able to provide one. If we move on to the next topic, so renters reform white paper. Just before that, thank you very much. I can see 17 questions have come in so far. If you have any more, please do submit them. We'd love to hear your questions and comments, and we'll deal with them as part of the next section. So we've talked about possession claims, so what is happening now, what is happening in the immediate future, the same for right to rent changes, and a brief update on Northwood Solihull. Looking a little further ahead, David, what is the renters reform white paper and why should the audience care about it?
Well, it's a mixture really of kind of good news and bad news. I mean, the first point to make here is that everyone had assumed that Section 21 was being got rid of, and that's where we were as we ran up to the last Queen's speech. And even after the speech, a lot of people jumped on a throwaway line by the Queen saying that the government would ensure protection for tenants, to think that Section 21 was being got rid of. But if you go and look at the background briefing document for the Queen's speech, it's quite clear that's not what they're saying anymore. So in the last Queen's speech a year ago, the government actually put in their background briefing that they were going to get rid of Section 21 and were going to introduce a bill to do so, which was the Renters Reform Bill. And it was going to appear in the spring and the summer and then this autumn. And that bill is not going to appear, and the government is not committing to getting rid of Section 21. What the government is now committing to doing is reviewing the entire package of rights and protections for tenants and landlords. So a more comprehensive review of the sector again, and to publish a white paper in the autumn, which may or may not lead to one or more bills moving forward into 2022. But what all of this, of course, means is that one, Section 21 is not definitely being got rid of. We'll have to see. Two, the government is quite keen on doing something around standards, and a number of different things are being proposed, which I'm sure we'll talk about in a moment. And also the government's throwing in some new topics into the mix, some of which are old and some of which are a bit new, around landlord registration, property ombudsmen, and things like that, which I'm guessing we're about to talk about. And I'm just waiting for Raj to cue me in to talk about one of those.
So I'd love to start with talking about the landlord ombudsman and landlord registration, and in particular how the two of them interrelate and whether in fact there is a need. And we're about to run a poll for the very first time. This is exciting. So if you'd like to talk about that, then we'll run a poll and get the audience sentiment.
A poll, exciting. Oh, there we go. There's a poll. Go on. Let's see a poll.
So should the government, in fact, establish a landlord ombudsman? Yes, no, not sure. If you could please click on one of those buttons. And when we have sufficient responses, my colleague Remy will take it away and we'll see what people's thoughts are. And then David will give you a sort of overview of what the government's proposals are. The answers are still coming in. Remy has just messaged me. And I think she's about to close the poll. And there we go. I don't know if you can see them on your screen. 60% of people think yes, 6% no, 34% not sure. Maybe if we run it again after David's done his piece, I'm not even sure if that's possible. But David, do you want to give us an overview of what the government's proposing and thinking, please?
Oh, I actually don't agree with anybody who said yes. So I'll explain why in a minute. Basically, I mean, the government it obviously has an ombudsman for now, and it has compulsory redress for all agents. But obviously, there's gaps there. If you're a very large landlord who doesn't use an agent, it's a bit weird that people have in a sense less redress. And the government also wants to have ombudsmen and is committed to producing an ombudsman for new homes. So the new homes ombudsman, they're quite far advanced in that process now, and they're already looking for tenders for someone to run that scheme, and that's going to happen fairly shortly. That's to deal, of course, with new build property and quality in the new build sector. So the government is sort of wanting to sort of complete the triad, as it were, by having all landlords join an ombudsman. Now, the difficulty about this is that they're not very clear what this means, because what is an ombudsman for landlords and tenants supposed to do? If it's dealing with agents, then there are things that fall outside the strict legal obligation of agents that fall within the remit of what I would call service quality, which is an ombudsman thing. Landlords don't really have a service quality obligation. They have legal obligations which are dealt with through the courts. And so I think the difficulty with a landlord ombudsman is what are they going to do? Are they going to be like a budget version of the courts, or an alternative to court, like I suppose the tenancy deposit protection is? Or are they only going to deal with a much smaller sort of group of things that are more to do with service quality? Or are they going to try and take over? I mean, and the obvious example of this is what happens if a landlord doesn't repair the property? Who does the tenant take their disrepair complaint to? There's already quite a large spectrum of options in there. Are we now adding another one? Do we say that disrepair claims no longer go through the county courts, but go to the landlord ombudsman? Or does it not really deal with that? Does it deal with smaller beer stuff? In which case, what's the point? So I'm a bit skeptical, and the government's not yet set out exactly what it means by a landlord ombudsman and what the remit will be. And I think that would be quite a critical question. In practice, I think the other point about this, which becomes dangerous from a lawyer's perspective, I hasten to add, is that ombudsman almost always equals code of practice. And codes of practice are difficult things as a rule from a legal perspective. They sit in a very tense place between being actual rules you have to follow and stuff that's merely optional.
Thank you. Sorry, I'm just checking, as there are so very many questions coming in. In just sort of staying on the renters reform white paper. So we were in a position where it was previously, or at least my take was, it was when, not if, Section 21 would be abolished, and that's not necessarily what the messaging is now. Aside from a desire to holistically review the private rented sector, do you have any steer on what the government's thoughts are from the white paper on possession more generally, and lifetime tenancies, lifetime deposits, or any of the big topics like that?
They haven't said about possession more generally. They have again talked about the idea of the lifetime deposit. The government is really in a very complex place on this. I think, truth be told, that they would like to. I think what they're really thinking about is getting rid of tenancy deposits altogether, actually, and finding some totally different way to do it. The trouble is that they're not really sure what that way is, and I suspect what will actually happen is we'll see some divergence, and then things will start to settle into one or more schemes. And to be honest, some version of an insurance policy, although probably not at the price point we currently are, with deposit replacement schemes, is likely to be the government's thinking. But there are other possibilities involving bank accounts and underwritten amounts held in bank accounts that are all being talked about as well. But the summary is that the government's not mega keen on the idea that tenants particularly have to have two tenancy deposits. When they move out of one property and move into the next, there's two deposits sitting there. The government would prefer in some way to reduce that cost if it can. But it's having real difficulty getting there, because the reality is how do you reduce it? The stats aren't very helpful to you here. The stats say that most tenants don't have any deductions made, or they're very small. But of course, for the tenants who do have deductions made, they tend to be all of the deposit. So about 30% of tenants don't have deductions made, but the amount of deduction tends to be all of the deposit. So it's not very helpful to say, as has then been recast, that's been reused to say 30% of deposit, 30% of deposits don't need reducing, therefore we can give them back early. But it's ignoring the fact that for 30% of people, they would then have nothing. So it's messy. And I think the other thing that's quite interesting is the government has talked about standards, and the idea of the property MOT is starting to be re-bumped back up. And that's not really a new standard, but it's trying to bring together the increasing plethora of standards into a much clearer place, which I think is probably a good thing, but I think it will have effects, because it still remains the case that landlords in particular are really reluctant to buy into their gas safety certificates and things until the last possible minute to maximize the length of time on the certificate. I think a property MOT is likely to force people to get those things much earlier in the space at the point of marketing, so pulling some of the cost forward. And the other difficulty or the other area that I think is interesting is the government threw in as a line, that I think is actually potentially the most interesting part of the white paper, the idea of landlord registration. And it said it's going to explore the merits of landlord registration. It's worth noting that England is now an outlier in the UK, because Wales, Scotland, Northern Ireland all have landlord registration, and the Isle of Man and Jersey are also exploring it and actually have bills before their respective parliamentary bodies to have quasi-landlord registration of various sorts in place. But of course, there's a pretty wide range of options on landlord registration. Northern Ireland, for example, is like mega light touch. It's literally a list. And there isn't even a fit and proper person test to get onto it. You just have to fill in a form and pay £30. If it's Wales, it's mega heavy touch. It's It's registration, licensing, training courses, fit and proper person test, code of practice. So where do you sit in that? And of course, that then has effects. If the government creates a list of all landlords, I mean, you've also got this weirdness then of how this fits with the property ombudsman. If every landlord wants to join a property ombudsman, then isn't that kind of a list of landlords anyway? So why do you then need a registration scheme? If you say that all landlords have to be registered and they have to be fit and proper, then the immediate question is, why do you then have selective licensing in some local authority areas? Because selective licensing is little more than a fit and proper person test and a bit of management rules. So you should get rid of all of those schemes, but then local authorities will say, oh, no, we need selective licensing, frankly, to help them fund some of their enforcement activities. So where do you find the funding from? So it's not as sort of simple as simply saying, oh, let's have a landlord registration scheme, which in general I don't think is the worst thing that we could do, but I think it has a lot of effects that sit off the back of it that need to be thought through. I suspect they may not be thought through, but we'll have to see as the white paper starts to emerge. But I suspect landlord registration is certainly on the minds of government. My feel from civil servants is that they see landlord registration actually in part as something that would allow them to communicate better with landlords. And one of their big beefs has always been the difficulty of communicating with the sector. And Wales has been quite good about using Rent Smart Wales as an active communications tool. So that might well be a factor in their minds.
Has there been any interplay with Rent Smart Wales or any other landlord registration schemes and the collection of tax? Because there is a theory that certain landlords do not declare their rental income. So has that sort of...
It's not really a theory. It's I think the stats are that about half of rent is undeclared.
So has that been joined up yet?
Well, will HMRC be using a landlord registration scheme? Yes. HMRC will collect data from anybody they can. And yes, I think it's inevitable that any kind of landlord registration scheme will have a tax incentive sitting behind it for sure. Do HMRC collect data from Rent Smart Wales and so on? I don't know off the top of my head, but I'd be very surprised if they don't.
Thank you.
No, I think the difficulty, of course, is always with these things. As soon as you say that, is then you immediately encourage lack of compliance. So how are you going to make sure that everyone signs up? And the sign-up stats for Rent Smart Wales are still not great.
Before we come on to the audience questions, of which there are many, but please do continue to send them in, which we can pick out the themes that have been asked. I would sort of summarize the key issue for the letting sector over the past, let's call it 18 months, being the changes around notice periods and possession. That's been really the hot topic. For our clients in the block management and social housing sectors, the key thing or the hot topic has been the EWS1 process, EWS1 certificates, inspections, remedial works for cladding. And we're starting to see more questions come through from our lettings clients about what they ought to do. So just as a slight side note before we come into the audience questions, David, what should agents do if they're renting out a flat where there's an EWS1 certificate for the property?
Oh wow, there's a long question. I thought you said that was next time.
Well, we will cover it in depth next time. But do you have anything?
Well, I mean, the general position is that I think letting agents need to bear in mind that they have a duty to and an obligation under the CPRs to tell tenants anything which a reasonable tenant would want to know. If there was an EWS1 that makes commentary about the perceived safety or otherwise of the property, whatever your views might be on that, and that is likely to be something which a reasonable tenant is going to want to know, and they should be made aware of the EWS1 and its findings. But I mean, you also need to bear in mind that an EWS1 is not a statutory document. You're not obliged to get one. And they exist primarily as part of a deal between the RICS and mortgage providers to increase comfort in the mortgage lending process. They're not something you have to have. That said, obviously, that doesn't mean that you can blithely ignore the fact your property may or may not be fire safe, simply because no one cares about cares about it from a lending perspective. Agents are under an obligation to take reasonable steps to ensure that the properties that they're letting are reasonably safe to an average person.
For anyone in the audience who wants to know more about EWS1 certificates and process, we held a webinar with RICS, ARMA, so the Association of Residential Managing Agents, so the block management trade body, IRPM, and others. And the webinar and the write-up are available from the Fixflo website, so you can access them there. Thank you very much, David, and thank you very much for all of the questions, which are currently being compiled by my colleague Remy, which is why I'm looking down as they're flashing up on my screen. I'd like to start with Northwood Solihull, if that's okay. So there have been lots of questions asked about the signing requirements. So the first thing to flag is we put together a guide. I say we very grandly. David very kindly put together a guide which we published on the requirements around signing documents, which we can try and include in the follow-up to this webinar if it's not too late. Otherwise, it's available from our website, and so you'll be able to get chapter and verse on that. But I guess the key question is, who is allowed to sign documents? And I suspect your answer is going to be, we're going to find out through the results of the Northwood Solihull case as it goes through the courts. But David, is there anything you'd like to add to that?
Well, I mean, the starting point is that the current position, according to the High Court, is that it has to be a director before witnesses, or two directors. My view is that the High Court case is wrong. I make no bones about that. Hence the reason that we're going to go to the Court of Appeal. I'm hoping the Court of Appeal will agree with me. They may not. The safest position for everybody right now would be to sign everything with a director before a witness, or two directors. But I recognise that that's easy for me to say and rather hard for people to put into practice. And so you'll have to decide what level of risk you want to run until the law is sorted out in the end of the year.
And I guess following on from that, so that's dealing with documents, certificates and the like being signed at the moment. And then you've got what I describe as the huge rump of historical documents that may not have been signed in that way.
Well, you can't, nothing fixes those from a financial point of view. You may choose to sign them in order to ensure that Section 21 notices were valid.
Yeah.
So if you wanted to protect a Section 21 notice and be safe, it would be sensible to sign one in front of a director, by a director in front of a witness, and reserve it on a without prejudice basis, simply to ensure that your Section 21 was good. But obviously that won't fix a claim for the financial penalties, because that's a historic claim. And if someone is being approached with a claim based on Northwood Solihull right now, the correct thing to do would be to deflect and defer it for as long as possible, until hopefully the Court of Appeal pops up and says that we're right. He says. I'm pretty confident. I'm putting faces, but the reality is, I mean, I'm doing this case for free if I lose. So I'm a lawyer at the end of the day. You've got to assume that I'm not doing it on the basis that I'm just a very lovely guy. I'm doing it on the basis that I'm expecting to get paid. So I'm pretty confident.
We've had various permutations of the same question, which I'm going to distill as, if landlord is a limited company, but agency is sole proprietor, or vice versa, what are the rules? It comes down to who is signing the document. So whether it is the agent on behalf of the landlord, in which case it's the agent's required rules, or the landlord themselves, and it's the rules that apply to them. So
to cover all those permutations very quickly, if the landlord's a sole proprietor and the agent's a corporate, then getting the landlord to sign it avoids the problem, and that would be an easy option, especially with e-signing systems. If the landlord's a corporate and the agent's a sole trader, then the agent can sign it, and that will solve the problem. which is an easy solution. This is only an issue where we're talking about corporate entities signing on behalf of a corporate entity. I mean, the law allows for agents specifically to sign on behalf of landlords. The issue here is very much about where the agent is signing on behalf of the landlord and the agent's a corporate entity, or the landlord is signing on behalf of the landlord and the landlord is a corporate entity, but doesn't affix a full corporate entity signature. And the difference here is obviously, and someone did raise this in the questions in a roundabout way, the difference between a simple contract, which of course can be signed by an individual and ratified by the company later, and the signing of a certification for tenancy deposit protection purposes, which the High Court has held is different and is a special type of statutory document that needs a better quality signature. So I mean, people are saying, oh, can't the directors just authorize anyone to sign it? Well, in principle, yes, but in practice, probably not, at least for as long as the High Court ruling holds.
Looking forward to the update on this case in hopefully the next week.
I mean, to make it more complicated, the whole thing is really about a very complex issue around the law of agency. And the problem in the High Court is that the High Court, unfortunately, didn't grapple very well with the idea of the law of agency and got a bit sidetracked into questions of corporate signatures. And the argument in the Court of Appeal will be very much more based around issues of what is an agent, who is an agent, who can be an agent.
Thank you, David. And hopefully that covers off most of the permutations of the questions that were asked there. Just as a reminder, again, there is a guide on signing documents by JMW, which is available on the Fixflo website, and we will try and put it in the follow-up, although I suspect we may be too late for today's webinar, but it's available from the Fixflo website. A slight side note on that, or in fact, slightly different altogether, which is EPC's minimum energy efficiency standards. Is there any news or anything changing about the stepping up of the EPC ratings? The question came in that indicated that about 50% of the person's rental properties are going to be unlettable without significant works being carried out. Is there anything that looks like it will change, or are we just on a one-way road to net zero?
The government has had its consultation, and the consultation was for a C rating with expenditure of up to 10 grand. So if you can make it C rated for less than 10 grand, you've got to do it. But they're also, it's a bit more subtle than that. They're actually now looking at potentially two types of rating, because of course an EPC is actually calculating what it costs to heat your property and light it for a year. So you could have a really inefficient property that's streaming out carbon everywhere, but you could stick loads and loads of solar panels on it and therefore achieve a low EPC rating without it being particularly efficient. So what they're now thinking about doing is a twin rating system where there's an EPC, and I think it's called an ECC rating. So one tells you how much carbon your property produces, and one tells you what it costs to heat and light it for a year. And they're hoping to make the things more even so that people will not just, people will be encouraged to move then to more carbon efficient systems. So for example, you could put in a gas boiler right now, a modern gas boiler, which obviously is going to reduce your EPC rating, but it's still burning gas. Whereas if you put in a air source heat pump, it's going to actually reduce both it's going to cost you a lot of capital. Obviously, you can apply for the renewable heat incentive till it goes away in March next year. But it would have two effects. It would reduce the cost, and it would also reduce the carbon rating of your property, because you'd be heating it on a much lower carbon budget, because air source heat pumps are more efficient in terms of carbon production. And if you twin them with a solar panel to provide the electricity to run the air source heat pump, then you're really on the track to very low carbon budgets indeed. So I think that the thing is going to change towards a much more of a focus on carbon than a focus on pounds, although the two things are inevitably tied up. But yeah, there is a recognition that a lot of property is way below C standard, and the government, unfortunately, it's kind of okay with that because it doesn't really have a choice. I mean, the reality is that most of our carbon comes out of our houses. people get very focused on cars, but the reality is actually that cars have become hugely more efficient, are going to get more efficient, especially as we move to electric cars. So your next big target spot has got to be the place where you spend most of your time, which is your house. And we can't meet net zero without improving our house efficiency. It's just the reality of it. I mean, that the fact is, of course, that the reason that we're having so much trouble compared to a lot of countries is that our housing stock is very, very old by comparison with other European countries, because we haven't knocked it down and rebuilt it. I suppose you could argue that some countries have had the advantage of having theirs bombed flat in the 1940s by us, but that would be an unhelpful way of looking at it.
We have a lot of questions, so I'm trying to bring together the themes to the best extent possible. Section 21 notices in England. David, what are the notice periods and from when?
They are 4 months.
And will
at
they
the
change?
moment,
And
until the expectation is the 1st of October, when they should drop back to 2 months, but we'll have to wait and see.
Okay. Right to rent checks, many questions. And I guess that I'm again trying to pick up on the themes. Do you have to recheck right to rent for renewals when they have a previously permanent right to rent? I think it's probably the simplest.
No, not if people have a permanent right to rent. Just as you didn't need to recheck before.
And so a renewal does not count as a new tenancy for the checks.
No.
Okay. And sorry, again, just trying to sort of bring the themes together. Hopefully nobody will get them wrong. What, though, are the potential penalties for getting right to rent checks incorrect, or not doing them correctly, or doing the appropriate follow-ups when they expire, or basically just not complying with the rules? And to what extent is that liability able to be passed on to third-party providers of right to rent check services?
Okay, there's two separate questions. I mean, the first point is the ultimate liability is going to prison, although no one's yet done so and no one's been prosecuted, but quite a few people have been civil penaltied. So you can get a civil penalty, or they can simply prosecute you and send you to jail. Third-party liability is not possible. So the way the system works is landlords are liable unless they have agreed in writing for an agent to be liable. Agents cannot pass on their liability. Now, however, just to cut across that, there is no particular reason in theory why a landlord couldn't agree to have an agent who was just the agent for the right to rent check. So effectively you have two agents, your letting agent and your right to rent check agent. So I suppose in theory that's possible. I'm not aware of anyone actually having done that yet. But it's not possible for agents to pass on the liability to a third party. Can't be done.
A practical question, which is roughly how long is it taking to get bailiffs appointed? The person who asked the question said we were granted possession 5 months ago and still have no dates for bailiff's appointment. So what's the sort of backlog that you're hearing or seeing?
That sounds suspiciously long. I haven't heard of anyone having to wait 5 months. Are you sure that whoever's dealing with it is dealing with it right? Because if you were granted it 5 months ago, you should have had to. You might have got stuck in the reactivation notice regime, even though you're not supposed to have a reactivation notice. So I would suggest getting in touch and finding out what's going on. That seems long to me, but it is very variable across the country.
I'm going to take this because it's highlighted, but it's a horribly complex question, I think. So,
okay.
Various landlords selling, but completions are delayed. Not surprising, I've heard of lots of completions being delayed, whether by owner-occupiers or by landlords. Asking if they can keep the tenant in for a period of, or put someone in for a very short period. the person said that they've been advising to put the person in via a license to occupy to avoid the minimum term criteria. Are you about to? Okay.
I mean, if someone has exclusive possession of the property and it's their home, it's an AST. You can call it whatever you want, but it's not. In many cases, it won't matter. Quite possibly, if they're going to purchase the property and you're sticking them in a license, and then they're buying it, because the thing will fall away. If you're doing it on a temporary basis to allow them to be easily removed to allow you to sell to a third party, that's not going to work.
If it looks like a frog, jumps like a frog, and sounds like a frog, it's a frog, and it doesn't matter what you call it.
Absolutely, yeah. I'm sure that one's meant to be more about spades, isn't it?
Yeah, it's, I can't remember what it was. Street and Mountford back in the day. And just one GDPR question, because I saw the letters GDPR there, and I knew that if we had a question about GDPR, you would be upset if I didn't ask it. If landlords are signing, they will. I'm going to rephrase the question. If landlords are signing documents, will they need to register with the ICO? We carry out all the work on behalf of the landlords, so they're not required to register. So this ties back to a Northwood Solihull. If the landlord's signing documents for themselves, rather than asking the agent to do so, does that trigger any responsibility or requirement to register with the ICO?
I did type an answer to this question, but the answer to that is you need to review a position on the GDPR. A landlord is almost certainly required to register with the ICO. It doesn't matter what they're signing. It's got nothing to do with it. It's whether they control the data that's the issue.
Yep.
Signing a document or not signing a document has got nothing whatsoever to do with their status as a data controller.
Perfect. And with that, so apologies.
More likely than not that they are in fact data controllers and do need to register with the ICO.
Just flicking through. We managed to get through the vast majority of questions, so thank you very much for all of them. Apologies if we didn't get to cover off your question. As a reminder, a guide on signing documents is available from the Fixflo website and possibly through the follow-up. If you're interested in learning more about the EWS1 process, please check out the webinar on the Fixflo website. We will be covering that off in more detail on the next quarterly legal update. If you could take a moment at the end of the webinar to provide us with feedback and any suggested topics that you would find interesting in a following or subsequent quarterly update, that would be great. Thank you so much for joining us today. David, very, very grateful for you sharing your time and insights and expertise once again. Again, all webinars are available via our website. But it's been great to be able to cover off so many of your questions. If you'd like to know what we're up to, please follow us on all good social media channels. And if you have any feedback or questions, please take a moment at the end to fill in the form or email us at research@fixflo.com. And with that, I wish you all a very good day and thank you again for attending.